Next speaker is our the partner from Cleary law firm, Kenneth Reinker. So thank you, Kenneth, for joining us. And please, the floor is yours.
Great. Thank you for having me. I would say this is a great conference with many wonderful speakers, so I'm very happy to be here. I thought I would talk a little bit about nascent acquisitions or killer acquisitions and how the agencies have been approaching those, and where I think that application of the precautionary principle to block these nascent and killer acquisitions can have very harmful effects, and where I think the agencies are moving in a bad direction or an under-considered direction. So I think we all know what a nascent competitor or killer acquisition is. These are smaller firms that could or might in the future compete with a monopolist firm. And the basic concern is just that the monopolist could either could acquire one firm, or maybe there's a sequence of acquisitions of smaller firms, and by doing so, snuff out the potential for future competition that they would otherwise face. And this has been the focus of a number of recent cases. I think it's a focus of the FTC in revising the merger guidelines. There's obviously the Facebook case that is pending, that is sort of their poster child for this theory. But it's been a theory in a number of other cases before. I'm not involved in the Facebook case at all, and I'll just say that I think it's quite an odd choice as a poster child for a nascent competition claim, given that Instagram and WhatsApp. So this is a case, obviously, where the FTC is challenging prior acquisitions by Facebook of Instagram in 2012 and WhatsApp in 2014. Instagram and WhatsApp are pretty clearly different than Facebook, quite differentiated. The complaint says that these acquisitions were in areas where Facebook had tried to compete and failed. It seems like there's obvious pro-competitive efficiencies for those transactions. The value of the transactions was relatively low compared to Facebook's size. So it's quite an odd, I'm quite confused why the agency is bringing the case. And like I said, I'm not involved in it. So just, again, I mean, there's this concern that a nascent player could develop into a significant competitor in the future that motivates these cases. But I guess I would question first, how serious are those concerns in most cases? Like, how realistic are those concerns? With most of these small firms, there's uncertain prospects about whether they're going to become a significant competitor, whether they're going to actually succeed, or whether they could fail and exit the market completely. And especially in highly innovative markets, I think it's very difficult to predict with any certainty whether one firm will or will not succeed. There's also sort of an internal contradiction a little bit. Like, if a firm is really a nascent competitor, what is it that makes that firm special? Is there some sort of IP that makes that firm special? Are there some other barriers out there that prevent some other firm from doing the same thing? I think in a lot of cases, what you see is that there's lots of small firms out there that are pursuing the same opportunity or could be pursuing the same opportunity. And it's not obvious what makes any one particular firm special. There's also the obvious point that, big firms that are competing in adjacent spaces could enter or expand. And a lot of times the nascent firms at issue are not really direct competitors to the monopolists at all. They're sort of complements, or they're in adjacent spaces, which I think makes it more difficult to really explain why the competition concern is serious. So, I mean, I think not to say that there's never concerns about acquisitions of nascent competitors, but while merger review is always forward-looking and predictive, in nascent acquisitions, it seems particularly uncertain, particularly speculative to say that there's effects. On the other hand, it does seem like there's obvious potential pro-competitive efficiencies from acquisitions by bigger firms or smaller firms. And there have been some quite disturbing statements from the agencies recently about the relevance of efficiencies. I think in the first talk today, Commissioner Wilson said that the head of the Bureau of Competition this morning said that she couldn't think of any efficiencies from mergers. Quite disturbing. But with acquisitions of big firms or small firms, there's just some obvious efficiencies. You can roll out the offering to a wider audience. You can roll that out more quickly. You can do that with more certainty. You can bring organizational expertise. You can provide more investments. You can take the talent that you're acquiring and use those to benefit a wider audience. You can more efficiently deploy resources. So, a lot of the time, there's going to be significant efficiencies that need to be considered. And I think that's particularly important with nascent acquisitions because the efficiency benefits are going to often be a lot more certain than the anti-competitive effects, and they're often going to be able to be achieved more quickly. So when you're talking about potential anti-competitive effects at some point in the future that are speculative, and you're weighing those against efficiency benefits that are relatively certain in the near term, it seems to tip the scale in one direction. And there's also the general point, Oliver Williamson and all that relatively small increases in efficiencies can swamp sort of the potential losses from slightly higher prices. So I have a lot of concerns about even when you're even ex post sort of balancing the potential anti-competitive effects versus the potential competitive benefits. And I think the other point, though, is that you can't just focus on the ex post efficiencies. You have to think about the ex ante effects of increased enforcement against nascent mergers. And I worry here about the significant effects on innovation when you start blocking big firms from acquiring small firms. And one reason somebody I think might have mentioned this earlier, it's the reason that people invest in small firms. The reason people create new firms is exit opportunities. They're not doing it just for the fun of it. They're trying to have an exit opportunity. They're trying to sell themselves. And if you make that exit more difficult, you're going to drive down investment. There's also a point that I think came up in the Illumina Grail discussion about just the optimal organization of R&D efforts could be to have smaller firms doing the R&D. There could be lots of reasons why a smaller company might be better positioned to innovate or be more willing to take on risk or pursue different alternatives. And then if that's successful, the bigger firm might want to bring that innovation in-house. And you would, by being more aggressive in these acquisitions of nascent competitors, you prevent that type of optimal structure of R&D efforts. And, then I guess I don't know if this is ex ante or ex post, but to the extent that you bring these acquisitions long after the acquisition occurred, like Facebook, I think the case against Facebook was brought in 2020 for acquisitions that happened in 2014 and 2012. If that becomes a practice, then you discourage investment in the products even after the acquisition happens. Because if you end up investing in the new firm and making it very successful, then you're sort of signing your own death warrant or whatever the phrase might be if the FTC is going to use that success against you. So those are sort of the concerns that from a practitioner's perspective, some of the concerns about this area. There's also been debate about the appropriate legal standard. And I'd be interested in people's views on this, but to me, there is a well-established potential competition doctrine where you look at how likely will the entry be of the potential competitor? Is there something unique or special about the potential entrant? And can you demonstrate that the entry by this firm would have pro-competitive benefits? So that's sort of the traditional standard. Set against that is recently the agencies have been arguing that the Microsoft case, which Professor Rubenfeld just talked about, the Microsoft case does away with all of that. And instead, all you have to do is show that the acquisition could be, quote, reasonably capable, end quote, of contributing to monopoly power. I thought this came up in a case that I did, 5 years ago, something like that involving Mallinckrodt. I've always thought this was a very strange standard, both because it seems like a clear misreading of the Microsoft case because this language comes in the causation section, and causation in a government case comes, obviously the causation standard is lower, and it came well after the anti-competitive conduct had already been established. And it also just seems strange to me to try to say that Section 2 creates a lower standard, a lower threshold than Section 7, given, the history, the text, the precedent in those areas. But this is what the agencies seem to be pressing, is they don't actually have to show likely anti-competitive effects. They can just show some reasonable capability, which is, in some ways, an example of antitrust laws embodying the precautionary principle in a harmful way. I think I've hit this point already, but I'll just briefly say, there's also a significant risk of what I would call Monday morning quarterbacking of, once, and the FTC's Facebook case clearly illustrates this. So there's an acquisition, you see that the acquired firm is successful after the acquisition. So Instagram and WhatsApp, very successful after the acquisition. How do you distinguish whether that's because Facebook bought them and rolled them out, or whether it was because they actually were successful? And what about all the dozens, I assume there's dozens and dozens of acquisitions that Facebook has made that are not now household names? What about those less successful deals? You pick the couple of winners and you challenge those deals and you ignore the unsuccessful deals. So in some ways, there's also this risk of being damned either way. If you acquire something and you're successful, then later on, the FTC says, well, that was a significant potential competitor. You bought it. If you acquire something and it's not successful, then they say, well, you bought it and you killed it. It wasn't successful because you killed it. And so I don't know how, I think it creates a lot of uncertainty and a lot of subjectivity that comes into this, as opposed to the, greater objectivity that would come from more traditional economic approaches. You're sort of replacing the more objective traditional antitrust analysis with the subjective opinions of lawyers. And my own view as a lawyer is lawyers don't know much and have a lot of biases, and that's probably not a great way to run a railroad. I guess the last point I'll just add is just there also seems to be, and maybe this is another embodiment of the precautionary principle, sort of an asymmetry. So when the agencies are trying to show an anti-competitive effect, they say, let's have a low standard of proof. Let's say reasonably capable of harm is good enough to show an anti-competitive effect. But on the other hand, if you're going to have such a low standard of proof for anti-competitive effects, what about for things like efficiencies? What about things like entry and expansion by other firms? If you apply, it seems to me that you should be applying a balanced approach and applying a lower standard of proof on efficiencies and entry and expansion as well. And that, ultimately you need to be weighing these two things and seeing if on balance there's an effect rather than applying a low standard on one side and not the other. So I don't know, those are some reflections from a practitioner that I thought tied into the precautionary principle. And I don't know if I've used up my time or not, but I'll pause there and I'll stop and either get us back on schedule or leave some more time for questions or whatever. But thank you again for inviting me. It's a great conference.
Thank you so much, Ken. It's a great set of contributions. I mean, I really appreciate that you circled back your reflections with the precautionary principle. I think that's right, that the way we can use incipiency doctrine in merger review can have some precautionary logic of just blocking sometime a merger just in the hypothetical harm for monopolization, even though there's a very low evidentiary threshold. So that's also the subjectivity of this analysis raise questions in terms of the rule of law and the predictability and the necessary objectivity of the rules.
This didn't really fit into the presentation, but let me just add one more thing on the precautionary principle. I guess I'm not sure I'm a huge fan of it generally, but at least in the environmental context or whatever, the idea is if we don't do the precautionary principle, the world will end. The oceans will boil.
And if we do it, it will end.
Well, right. So, but at least the logic is, if we let genetically modified organisms go out there, then everybody will die. You know, in antitrust, it's just, I don't see any basis for using that same type of logic. Like,
There's
no
no
one's
such
gonna,
thing as an antitrust emergency, one of my
right,
favorite
exactly.
things to
It's like,
And there's no
say.
like
such
what,
thing as a GMO emergency.
my phone's a
either.
little slower. My phone costs 10% more. It's like, where's the world ending thing that requires some precaution? But anyway, I'll be quiet now.
That's no, I mean, there's a time for question and answers. And unsurprisingly, Richard, do you have a question?
Yeah, I've deferred to Julie because I asked too many first questions.
I mean, this is more of a comment than a question, in the spirit of these things. But, you know, I think, Ken, you sort of highlight another example of something I raised earlier, that there is this sort of fire alarm that's been raised that, oh my gosh, look at all these killer acquisitions. We have to do something, right? And when you actually go and read the killer acquisitions paper that all of this hullabaloo started from, it's about pharma, and it's about substitute drug products. So this is a horizontal story, right? That if these transactions had been seen, they were all below the threshold. Had they been seen, my guess is that the agencies would have done something about them. But what they've done is they've taken that and sort of grafted it onto tech.
Right.
And, you know, Ginger Jin and her co-authors have a great series of papers that's actually looking at tech acquisitions. And guess what? They're largely not horizontal, right? They're largely in sort of adjacent spaces or complementary spaces. So less, you know, innovations that are going to disrupt the incumbent and more innovations that are complementary to what incumbents are already doing. And
Right.
It's just sort of another example of policy with no evidence.
Right. And I mean, and pharma, you know, it's not that there's no nascent acquisitions that create problems. And pharma is an example of where you can have a coherent policy, right? Because there's IP protection. There's a well understood development pathway where at each stage you have predicted probabilities of success at the different pathways. You have good visibility into who the other competitors are that are pursuing a particular condition. And so, you know, there's all sorts of reasons to think that the enforcement in pharma of pipeline deals, you know, might make some sense. But it's for reasons that really don't apply and can't be translated necessarily to other areas as well.
Richard?
Yeah, I mean, just before I ask my serious question, it's sort of the observations I recall when Facebook made this acquisition of Instagram or whatever it was in 2012, it was paying too much money for a ridiculous transaction, right?
Right.
And so the kind of question is, the hindsight stuff is really huge. I've got another question, which is one of the things that we've talked about throughout has been the choice of remedies that are to be applied in cases of admitted violations. And, you know, I'm going to talk a little bit about that and what time is allocated to me. But in this particular case, what's the remedy that you give, right? What are you supposed to say? We're going to spin this company off? And is Apple going to be allowed to say, well, we managed to invest X billion dollars in this particular situation? Can it give the complementary patents that it introduced and so forth? So as to say, in effect, that it's entitled to keep something if this thing is going to be spun off. If we do spin it off, are we going to spin it off to Apple shareholders, right? At which particular point there's no wealth transfer going one way or another. What you're doing is you're just breaking up one firm into two firms, then they'll combine through contracts where they need some situation. So what is it that you're trying to do under those circumstances? And third, is it the situation that the FTC or the DOJ is going to think that some kind of fine ought to be imposed retroactively upon that, which essentially hurts the shareholders in both corporations and doesn't do anything to advance efficiencies and so forth? So what I'm left with is a genuine puzzle. Given the interpertinence of the situation and the fact that there was certainly some efficiency or synergies that took place, right, after the acquisition, how do we structure the remedies in cases of this sort? And you know, you're an antitrust lawyer. You don't know any economics like me. You know, we're both very dumb. but you spend your time you're a remedies guy, right? I mean, lawyers' comparative advantage over other people is, we play the game of injunction, specific performance damages, fines, and all the rest of that stuff. And so using your remedial expertise, how would you remedy this problem?
Well, I guess I don't know if I have the answer, but a couple comments. One, there's no ability for the government to give fines, right, under the current law.
There's no ability for the government to do it, to impose fines.
To impose fines.
Yeah.
Until whatever law Congress is considering to reinstate the FTC's disgorgement powers gets.
Oh, that was also because of the recent AMG case, right?
Correct. So no fines.
Yeah. As of yesterday, or last week, there was.
Right. I mean, in terms of the remedies, this has come up in some prior cases, like the one that comes to mind is the Bizarre Voice Power Reviews merger, where these are two companies that did, like, what Amazon does with their reviews. These are two companies that did syndicated reviews on third-party websites. Pretty much the head-to-head competition. They bought them in a non-reportable deal, shut down one of the two businesses. The judge in that case ordered that, the case goes through a couple years later. The judge in that case ordered a divestiture to a buyer and ordered that the company, the acquiring company, license its IP and its improvements and its developments in the technology over the intervening years to the new company.
Free of charge?
That I can't remember. I assume there was some sort of payment for the business, so I don't know exactly the details of the payment. But the idea was you take the improved product and you license it to the new company. I guess a third point I would make is, the government, there are in private lawsuits, there are doctrines like latches and stuff that say you have to act quickly on your rights to avoid these very types of problems.
Yeah.
The government's always said, well, latches doesn't apply to the government on these public enforcement types of things.
Well, just like the adverse possession doctrine doesn't apply to the government.
I've never quite understood why it wouldn't make sense to apply latches to the government in this type of case and say, you guys need to act quickly, seek your remedies, and if you don't, you lose your rights to seek the remedies because of some of these insuperable problems that you're posing.
Well, I mean, I could give you an answer for the historical origin. The doctrine of adverse possession, the general movement has been to shorten the period of the permissible statute of limitations. And the argument is you don't have to go from one end of England to another by a horse in order to find out what's happening. And so therefore, we want to resolve these things sooner. But the doctrine has always remained that adverse possession never runs against the crown on the grounds that the king can do no wrong. And the other thing is, it turns out that the United States has taken the exact same doctrine. So I think what you're seeing is simply an extension from the adverse possession cases into the antitrust cases of that view that the government is so incompetent that it can never be forced to essentially to limit its rights. I don't think that's a functional justification, but in the adverse antitrust area, or the adverse possession area, the ground has been the government has so much property, it never knows what's going on with any of it, that in order to protect the public, we have to make peace with its incompetence.
Now here, of course, we have the government with a pre-merger notification regime where the deals are notified and actually reviewed, and then they bring the lawsuit later. And so whatever the functional justification might be in England, I'm not sure it applies.
It's crazy.
Here,
it's also, by the way, you didn't comment on the application of res judicata. In some sense, it's not a final judgment, it's a final administrative decree. But suppose it turned out you got judicial improvement for it. Could you get past that when you try to undo it?
So the government says, our HSR review, our allowing the waiting period to expire is not a decision by the government, right? It's not like a final adjudicated decision that has collateral estoppel effects or res judicata effects or any sort of preclusion effects. And so far, the courts have let those cases go through, and they haven't said that the government should be precluded.
I don't know. I don't know if you remember earlier when I described one of the antitrust cases that I've been involved with, right? The way in which this thing resolved is the government just stopped knocking on our door.
Right.
And what they refused to do is to give any final closure notice of what had happened. And so the client comes up and asks me, well, shouldn't we ask for this? And I told them, if you have a suicidal instinct, you may do so, because the price you pay for asking for a finality is somebody say, hey, let's look at this suit again, gets on a third desk and they're going to bring it.
That's
so
right.
I said, what you should just do is suffer in silence.
Yeah, never kick a sleeping dog.
And David, you agree too, right? So I gave good advice knowing nothing about the subject.
That should be day one of law school. Don't call the government or if you don't have to.
Well,
Maybe they'll go away. And I mean, I do wonder, what'll happen. The FTC is trying to do whatever they're trying to do. What happens in either November or what happens in 3 years or whenever the progressives are out of power, I don't know.
there will basically be a wholesale abandonment of cases.
Yeah. So there's
Some will be, but very few will be explicit, however.
right. And so there's a strategy. I mean, if you're in the
Draw it
practice,
out.
right, draw it out. And the progressives are actually helping you do that because the requests are broader than ever. There's more crazy questions than ever, and sort of drawing these things out. And what you've seen, I mean, there's been all this talk and angst about increased enforcement. There actually has been much less antitrust enforcement cases brought than there were under the Trump administration. I guess that might change with the appointment of the third FTC commissioner and with Jonathan Cantor being there. But at least so far, there's been a lot more procedure, a lot more investigation, a lot more, sort of tax on mergers, but without very much action at the end of it in terms of increased enforcement. Very strange.
Yeah, I mean, well,
That's-
I mean,
Sorry.
they basically have gone the investigative route with the FTC and the DOJ and their joint request for information, right?
Yeah. Well, it's
I mean-
also like the Illumina deal that you talked about, where they tried to outsource their dirty work a little bit to
Yeah.
European.
But I mean, but the difference is in the Illumina case, what you're doing, you're stopping a deal through dirty work. In this case, you're stopping your own enforcement mechanism because you want to have more and more information about this stuff. And I mean, every single area that I've looked at, they're wrong in terms of their notion that somehow or other increased enforcement is what we need in a world where I think private firms are there. In fact, I don't know, David, if you were here early in the morning, but what I did is you are representing people in the Illumina case, right? Right?
Yes, thank you, Richard. We represent Illumina.
Yeah, I mean, a
We're
minor
trying to
party
get that
and-
deal done.
Yeah, but you also gave the comment that you committed to compulsory arbitration, right? In order to avoid the holdout foreclosure problem. Right, and so, and the FTC does not refer to that when it makes its decision, either in the particular case or in its general situation. And I mean, and the Christine Varney started that several years ago in other transactions, didn't she? Also your partner.
Yeah, that I know Christine is my partner. I don't know if she did.
Yeah,
that
I
other
think in some of the
transactions.
others, I think that was also done in whatever it was, the Verizon, I can't remember, one of the big mergers with the companies. I think it's actually quite structural. And and the explanation that I gave before was, you don't want to foreclose even if you're given the right. So when you surrender a right to avoid an antitrust suit, you give up very little in the marketplace. And what you gain is a powerful immunity from the antitrust suit. So every sensible firm should do what you are doing. And I think you agree with that. Anyhow, it's actually with 3:15.
Yeah. No, it was a great discussion. Thank you so much, Ken. I mean,
Thank you, Ken.
on the decrease of enforcement, it reminds me of Professor Bill Kovacic, who said that the neo-Brandism revolutions may be over-promising and under-delivering. What they claim is precisely going to be hard to deliver on everything they promised, at least.
Or as Christine Wilson has said, governing is hard.
Right. So now it's time for governing.